Hi, friends. This is Kaushik Ranchod, immigration lawyer here in sunny Sacramento, California. Today, we're going to be talking about some top reasons that we're seeing that denials are occurring. So we're going to talk about that for different types of cases: J-1 waivers, green cards, I-601, I-601A waivers. So you'll want to stay tuned. And when you join, just say where you are watching from, because I always like to see that. It's amazing. A whole year has already gone by where the elections happened last year and decisions were made with the new administration entering in January. And we've seen so many changes. We've seen the highest number of deportations ever. But interestingly enough, a lot of those deportations have to do with self-deportations. So people just not wanting to deal with what is happening right now in the U.S. And the people who are staying are fiercely determined. There was an article in the New York Times talking about that, how people are determined to get legal, stay legal, and navigate the immigration process for those who are staying. And that's what we're here to on this live today, is to help you avoid mistakes when you file your application. And welcome to those of you who have joined. Please give a shout out. Let me know where you're from in the country. I'd love to learn where everyone's watching from. And what we are talking about today is mistakes that you want to avoid on different applications, what we're seeing in 2025. My name is Kaushik Ranchod. I'm an immigration lawyer, and I've been practicing for over 23 years. And we are going to talk about how some of the ways that we avoid denials in our office. So let's dive into it and talk about, first of all, the biggest mistake that you want to avoid. So one of the biggest mistakes is missing evidence, not providing evidence. And we see this in a variety of applications this year where people are coming to us and they're getting denials because missing evidence is not provided. So in that situation, let's look at it for a variety of different cases. So for example, for an exceptional hardship waiver, in that situation, we're seeing bare bone applications where statements may be provided, making assertions, oh, I'll face hardship. Let's look at an example, medical hardship, but there's no doctor's letter, there's no medical records to support that. So if you're going to make that assertion that you have medical hardship, it needs to have the appropriate documentation to go along with it. USCIS is not going to just take your word for it. And for marriage-based green cards, and if you're filing for a J-1 hardship waiver and you're married to a U.S. citizen or a lawful permanent resident spouse, that would be the next step in the process. The same theory of missing evidence is one of the top reasons for denials also occurs with marriage-based green cards. So people think that if you just submit your marriage certificate and complete the application, that's enough. Well, it's not. You have to show that your marriage is bona fide. So what that means is you have to demonstrate that it's real. And the way to do that, one of the ways, is by creating a narrative through the documentation. And some of the documentation, for instance, for marriage-based green cards that the government looks at, they want to see that you have things commingled. So bank statements, credit card statements, life insurance, utility bills, those are all some examples of documentation. So just submitting the application itself is not enough. It has to have substantial documentation. And with the I-601A, similar to the J-1 hardship waiver, also not including appropriate medical, financial, emotional hardship, evidence of those different categories, and just relying on completing the form. And that's not enough. Not only that, but you also have to have a narrative to support that. The way that we do that is through a legal brief. So we like to attack it in three different ways: having the appropriate documentation, having the narrative done through a legal brief, telling the story, making the legal arguments, and then also the statements as well. So all of those three ways to demonstrate that there is sufficient evidence and there is a narrative to go with it. And that leads me to the next big mistake that we see, is that there's not a proper narrative explaining the context of the hardships. So it's not just enough for a J1 hardship or an I-601A to demonstrate hardship. If so with I-601A or a J1 waiver, it's not just enough to just say, oh yeah, we have hardship. And we have a question along this lines here from Sandhya Ram. Hi, great to have you join. And the question is, how can you show if your husband is outside the country? It'd be helpful if you clarify a little bit on your question. Are you asking how do you show hardship if you're outside the country? I'm assuming that's what you're asking. But if you can clarify in your question, that'd be a little bit helpful. But I will, address that. If your spouse is outside the country, then you could talk about the hardships that you already are facing and documenting that, and that it wouldn't be sustainable if the hardship continues. All right. Mistake number 3 is wrong timing. This is especially true for exceptional hardship waivers. The process is taking so long. So right now, USCIS is taking about 20 and a half months to process exceptional hardship waivers. And then that's only for USCIS. You have the Department of State processing times. And so if you're on a J1 program, you only have so much time before your program ends. You may not be able to extend it. And unfortunately, people wait till it's too late. So if you're on a J1 visa, you want to start thinking about how you're going to stay in the United States if circumstances changed after you got here. Because waiting to the last minute, you're not going to be able to, you may not be able to continue to stay in the US. You might have to wait for your waiver while you are abroad. Okay, and let's move on to the next mistake. Listening to bad advice online. So there's a lot of people now who just are giving their opinion, who aren't qualified, who aren't lawyers, and watching a video on TikTok, or someone who's not qualified, like a notario. So let me give you an example. One of our clients went to a notario. Or you can also call them accountants who are practicing law without a license. And that's great if you have a very, very straightforward case that might or might not work. In this situation, it didn't work. They told them to go abroad. They had overstayed their visa for more than a year, and they were subject to a 10-year ban. So we had to file I-601 waiver while they're outside the United States. And that's the danger of going to someone who's not qualified, or following TikTok advice, or someone on YouTube who's not qualified and does not understand the nuances of the law. And even with ChatGPT, you have to understand and you have to provide the right prompts. And if you're not knowledgeable about the subject matter, then you're not going to get the right answer. So it's like garbage in, garbage out. And a lot of times with ChatGPT, it'll tell you what you want to hear. Okay. We have a question here submitted from Paramveer. I submitted a U visa July 11th, 2017. When do you think it'll get approved? Well, we're getting ours approved early 2017. So I'm hoping you're going to get yours approved soon, within 6 months. And then do you think they are hard on robbery U visa with knife and one handgun? Are they still approving a U visa? Yes, we're getting a number of our U visas approved. We recently got U visas approved, so I can only speak for our office. Robbery is a more difficult crime. We had a client who went to another attorney, filed under robbery, got a denial because they didn't file it correctly. You have to articulate that it falls within the appropriate crime, and robbery itself is not a crime that qualifies, and that's what USCIS's opinion now is, that robbery itself doesn't qualify, but if it falls within another type of crime, it may qualify. So, for example, if it falls within felonious assault, it may qualify, but your attorney has to know the nuances and know how to explain that correctly. Otherwise, it'll get denied. So in that client who came to us where they went where they got their case denied, were filing an appeal and showing that it is something more than just beyond robbery. It's a type of felonious assault. Okay. So, Sonia, thank you for just getting into your questions more, or answering more and providing more detail about your question. So your question is about showing proof you both own or have property or bank account together. So I have another question for you, Sandhya, and that question is, what kind of case are you filing? Are you filing for a green card abroad? Are you filing for a hardship waiver? Or did they have a ground of inadmissibility? That would help me answer your question, because if you have medical conditions and you're just filing for immigrant visa, will that help you get the person here faster? You might be able to apply for expedited I-130 approval, but those are difficult to get, and you have to have a really, really good reason. So I'll wait for you to give me more detail on what type of case you're applying for. And those are the main types of mistakes that we are seeing in 2025 that are causing denials. So you want to make sure that you avoid those mistakes. If you have questions about how to build your, if you qualify for a hardship waiver, how to avoid these mistakes, you can reach out to us at 916-613-3553 and post your comments below. Try to get to as many as I can. And want to thank you for joining our live today. Just stay calm through all the craziness. If you have a plan, it's still very possible. If you're strategic, if you build your case appropriately, it's still very possible to get an approval. And we look forward to seeing you in our next slide. Thank you. Bye for now. Okay, well, let's see. Sandhya just gave his response here. So I do want to try to answer your question. Okay, so so I think your question, you're asking about whether or not, what do you do if your person is living abroad and you're so you file an I-130. So yeah, in that situation, you're not going to have, like, for instance, bank statements or whatnot. So that you want to show like proof of relationship through correspondence, trips that you visited, WhatsApp chats, any gifts that you sent. So that's going to be different forms of evidence than if you're applying for a marriage-based green card in the United States, because not everything is going to apply. You're not going to have a bank account together in the if your spouse is abroad, and that's not typically, has not in the past been expected. All right. I want to thank you all for joining, and until next time, bye.